Hi, this is Professor David Opterbeck. In this unit, we'll talk about the types and costs of cybercrime, and we'll ask why we might consider some activities crimes at all. I gave you some readings on a case that dramatically illustrates the effects of criminalization. In some circles, Aaron Swartz is considered an internet martyr. As a teenager, he invented the RSS protocol, which was widely used to parse XML data for easy syndication of blogs and other content. He later developed a high profile among the copyleft, activists, academics, and others who think copyright laws and other online content limitations are too restrictive. In his early 20s, he downloaded a large quantity of articles from the JSTOR database licensed to the MIT library, in violation of JSTOR's terms of service, as a kind of act of civil disobedience. He was arrested and charged with serious Computer Fraud and Abuse Act violations by federal prosecutors, which could have resulted in a lengthy jail term. At age 26, while the case was still pending, he committed suicide. As the articles in your readings suggest, it's impossible to know exactly how much the pressure of the pending criminal charges contributed to Swartz's suicide. However, his case has led many to question whether the Computer Fraud and Abuse Act is too harsh, particularly in relation to supposedly innocent kinds of hacking. At the same time, others argue that the CFAA should be made even stricter. There's no doubt that cybercrime is a major economic and social problem. The Accenture Cost of Cybercrime study for 2019 found that the average cost of cybercrime in 2018 was $13 million per organization, up 12% from the prior year and up 72% over 5 years. According to the Accenture report, cybercrime is costly across industry sectors. We can classify cybercrime according to its motives. These include economic, profiting from the crime; personal, extracting revenge or imposing other personal harms; hacktivism, activity to make an ideological point; espionage, obtaining state secrets; terrorism, including overt terrorist acts and, more commonly, economic and personal crimes that support terror groups; and war. The parties engaged in economic, personal, and hacktivist cybercrimes tend to be individual actors, loose associations such as the hacktivist group Anonymous, and organized crime groups. The other three areas, espionage, terrorism, and war, are typically carried out by state actors and by non-state terror groups. The line between state actors and organized crime are often blurred. Russian-based organized crime with close ties to the Kremlin in particular is a major force in cyberspace. Chinese and North Korean groups perpetrating cybercrime in the U.S. often are government or military units. Of course, the U.S. also engages in cyber espionage and in activities that could be considered cyber war. Those activities, when conducted by the U.S. government or the U.S. military abroad, do not violate the Computer Fraud and Abuse Act, but might violate the domestic laws of other countries. In the first part of this course, we discussed the idea of Internet governance. One aspect of any concept of governance concerns the relationship between private actors where there has been some harm committed or there is some potential harm. The traditional domains of private law, torts, property, and contracts usually are the first line of recourse between private individuals. If you and I enter into a contract for the sale of a truckload of fresh eggs from my farm and I fail to deliver, there's an economic harm and you can sue me for breach of contract. If you are driving negligently and collide with another driver causing personal injury, there's a claim for negligence. These are not ordinarily matters for criminal law. The state and the positive law created by the state, however, still play an important role in private law matters. The content of private law, what is a breach of contract and what is the remedy, and the institutions through which recourse can be had, the courts, are produced by the state in accordance with the state's governing charter. In liberal democracies, a constitution. The principles of the private law and the institutions through which the private law are enforced are bound together in this constitutional structure. But there are some kinds of harms between private parties that we consider crimes, and that therefore are subject to a form of public law, the criminal law. Here, the state, acting on behalf of the people as a whole, plays a much more direct role in prosecuting the action and imposing a penalty or remedy. The criminal law is a particularly sensitive matter because through it the state may deprive a person of liberty, property, or even, where capital punishment is still recognized, of life. The criminal law, of course, is also bound within the society's constitutional structure, including the structure of civil rights that protect persons accused of crimes from arbitrary or excessive state power. But before we even need to invoke those constitutional protections against state prosecution, we want to try to ascertain whether the harm or potential harm from the conduct to be sanctioned really is serious enough to be criminalized, rather than left for resolution only by private law. Some principles of criminalization include the degree of harm to self and others, the degree to which the conduct limits another person's freedom, the degree of shock to the public conscience, and the de minimis principle, which says criminalization is a last resort after civil remedies. A final controversial factor in the contemporary context is the question of morality. The modern trend is to sever legal content from notions of morality, but questions of morality and justice inevitably pervade all the reasons we might give for or against criminalization. After all, why should we care if a particular harm is relatively minor or relatively severe? We care because we know there is something intrinsically valuable in human life and human freedom. Even if we decide some conduct is serious enough for potential criminalization, there are additional factors to consider. An important consideration is that a criminal law should be clearly defined and drafted so that people know what conduct might bring criminal sanctions. The rule of lenity is a canon of statutory construction that says if a criminal statute is ambiguous and can reasonably be interpreted in a way that favors the state or favors the accused, the interpretation that favors the accused must be adopted. The potential for enforcement also is important because criminal statutes that cannot be enforced or that are enforced highly selectively tend to undermine respect for the state and for the rule of law. For example, although speeding is more a kind of regulatory violation than a true criminal offense, think about how you feel about speed limits on local highways. Does anyone really go 50 miles per hour on Route 21? The extent and type of punishment is another key consideration. Even if you think Aaron Swartz should have been charged with a crime, you might wonder if the possibility of spending 10 years in federal prison for downloading too many JSTOR articles really makes sense. Penalties are particularly important because the vast majority of criminal charges are resolved through plea bargaining rather than through a trial. A prosecutor who can brandish the possibility of a long jail sentence can pressure a defendant to plead to a lesser charge, even if the defendant might have a good defense to all the charges. We rely on the professionalism and integrity of prosecutors in their exercise of prosecutorial discretion against excessive and abusive uses of their power. But we also want the substance of the law, including its penalty provisions, to limit the possibility for abuse. Finally, the criminal law should broadly cohere with other areas of the law, including private law and civil regulation. For example, if it was a crime to use encryption on certain kinds of information, but encrypting sensitive data is a best practice for cybersecurity compliance, this would obviously present a major problem. As we dig deeper into the CFAA and other computer crime laws, think about whether these principles of criminalization suggest the need for any changes, whether in the substance of what is considered a crime, in the wording of the statutes, or in the possible penalties.